neighbour disputes, again, a nightmare on the basis that what's the dispute about? And if we are buying a property that's subject to a dispute, as you mentioned earlier, we've got the potential for buying litigation.
Yeah.
So is it disclosed in the TA form, in which case further investigation required? If it's not disclosed in the TA form, then on inspection, going to talk to neighbours and finding out, what the lie of the land is, and if there are any problems, is useful. Boundary disputes we'll touch on in a moment or two. The other thing I think to watch out for is adverse possession. The fact that a neighbour has moved a garden fence or has been looking after a piece of land for a number of years, again, can just create a whole raft of different problems. The big problem I find is where you've had an adverse possession claim that's been unsuccessful.
Yeah.
If the adverse possessor is still in situ, he can make another claim after 2 years, and you can't defend it. He's entitled to his adverse possession unopposed, as it were.
Yeah.
So
you've got to boot them off, haven't you?
yeah, the adverse possession terrifies me on the basis that, plans, boundary, descriptions of the land, etc., all fall by the way. Issue, what's the adverse possessor actually occupying?
Yeah.
And the other thing that's interesting is when there is a risk of an adverse possession claim being made, as far as the clock ticking, if the owner of the land was suffering under a disability, the clock stops. So I'm dealing with something at the moment where the seller had dementia and was in a home for 4 years. So the clock stopped ticking with regard to the adverse possessor during that period of time. So he bangs a claim in and is unsuccessful on the basis that you can't claim against someone who doesn't have capacity.
Right.
So,
Yeah.
so the buyer of the property escaped it. And the last thing on adverse possession that I've seen, and this is terrifying, if you make a claim for adverse possession and the paper title owner objects, the land registry will refer the matter to first tier tribunal. And first tier tribunal these days is akin to a county court action with cost vulnerability. So if you object and you're unsuccessful, you're liable for the applicant's costs and vice versa. And I was just talking to counsel about this, and he dealt with a matter where his client had objected to an adverse possession claim unsuccessfully and was liable for £38,000 worth of legals. So lost his title and was liable for the applicant's legal costs.
Wow.
Yeah.
That's a lot of money.
It is, isn't it? And he was saying, if you're going to make a claim for adverse possession, a lot of conveyancers will just submit enough evidence to satisfy the land registry. Not every bit of evidence that you've got, but just enough on the basis that I'm not a litigator, I don't have the time, and I'm not really getting paid to do this, so we'll just pop it in and see what happens.
Yeah.
And what he was saying is he was involved in another matter where the applicant had done that, and then as the matter becomes contentious, had thrown in more evidence, and the tribunal had said, why didn't you submit all that evidence at the beginning? Because you've done that, you're going to pay the other side's costs in objecting up to the point that you've submitted this later evidence. Whereas if it had all been put in at the beginning, there wouldn't have been that cost vulnerability.
Yeah.
So I think the thing with that is first tier tribunal is proper property litigation. It's not something that you can play at, and it's not something you can say to the client, you can deal with this yourself. I don't think you can do that these days, unfortunately.
No, definitely not.
Yeah.
And the other thing is, you've got to look at that. And if you suddenly get a barrister or somebody else in to help you after you've gone into the land reg, no, it's always try and get things done right first time.
Absolutely. And
Chuck
the other thing
at it.
that barrister said, which is really interesting, if you're a conveyancer, have a look at what you're doing. If you're pinging an email across or being a bit bolshy, stop and say to yourself, if we get before a first tier tribunal, how does this look?
Yes.
Whereas if I've appeared to be reasonable and accommodating and fair, how does that look?
Yeah, I was always told that anyway, whenever I've done law. That was the first thing out of my teacher was awesome when I first left law school. And that was what we were always taught. always be careful and think, what if a judge looked at that?
Yeah, absolutely. Yeah.